There were some changes to accessory dwelling units in 2019, and these are they tend to be an interesting topic for lots of people. So I thought we'd just go over it, and it's also a good example of how the document kind of works together. So in 2019, we made it a little bit more clear, I hope, the difference between a dwelling unit accessory with a kitchen. So mother-in-law quarters, casitas, we call these lots of different things. It's really another unit on your lot, smaller than your house, that's got a kitchen in it, versus accessory dwelling units without a kitchen. So you can see that those are separate rows in the use table, allowed in different zones differently, and they're covered by the same use-specific standard. And so in the use-specific standard, you find all the rules about in R1, it's not allowed unless you're in a special area where it is allowed. So citywide, no accessory dwelling units with kitchens citywide. But if you're in an area that at some point decided and created a rule in their own plans to allow them, we carried those allowances over into the integrated development ordinance. And if you want to know where those are, wait one slide. And then if you want to know the definition, you can go to part 7, of course, with the definitions. And so looking at the next slide, if I want to know where are all of these places that an accessory dwelling unit is allowed in R1, I would go to the little IDO zoning map. I would go to button 4 because I have a question about a use. I click on button 4 and it brings up this pop-up box, and I can scroll down until I find dwelling unit accessory and click that button, and you'll see these few areas in Albuquerque where accessory dwelling units are allowed in R1 so accessory dwelling units with kitchens are allowed in R1 in these few places. So the other thing that kind of changed in 2019, we know, you and I know, wink, wink, there are a lot of accessory dwelling units outside of these areas, right? And maybe they were built before 1959, before the city had zoning, which means there were no rules. You were allowed to do it because no one said you couldn't. Some of them were built after 1959 and probably shouldn't have been, right? So the question of what to do with those existing units has been a head scratcher for a lot of us for a long time. So in 2019, the city council finally said, look, if you can prove that it was built before 1959 when it was legal because we didn't have zoning, then we're just going to consider that you have a permissive use. So basically legalizing your existing unit. If you can't prove that it was legal when you built it, then you're going to have to come in and get a conditional use approval from the city in order to use it as an accessory dwelling unit. And if you don't get it approved because you can't prove that it's not going to be harmful to your neighbors, let's say, then you can use it for storage. You can use it as a structure, but you can't use it as an accessory dwelling unit. So that's kind of how we're taking care of that moving forward.